Good morning, friends. We are live. It is Thursday, September 12th, and we are just moments away from Donna Adelson's pretrial hearing in front of Judge Everett. So we're just waiting for that to begin as people get into the live stream. I have the Long Crime stream up and ready to go, and it looks like they're on another matter right now. But
right, for everyone who is just added in the Zoom, please keep your devices on mute until your case is called.
There we go.
All of the other regular business of Division C will be handled before we get into the Adelson case. First up will be Christopher Beard, 2023 CF 1694. Mr. Beard, if you can turn on your video and audio, please.
So these are some other cases it
Good
looks
morning,
like.
Mr. Beard. Good morning. Ms. Fernandez?
Before we get into it.
I'm asking for the first December.
Good morning, T. Cancella. Hello. Welcome.
I granted the motion yesterday.
You're one of the first.
Case
So,
management for October,
congrats.
but you're just asking for December.
October might be best.
I'm fine with that, Judge.
2 steps forward, 2 more back. Are we sure you what you want?
I would like the October case management. There are things that we are waiting on. Talk to the state, and that should happen by the end of September, and that will help us determine the best method.
All right. Concerning the issue of whether or not any depositions need to be taken, is this part of the matter?
That is part of the matter.
Very well.
If you guys don't
October
mind,
16th at 9 o'clock.
Before we get into the
Trial date
Adelson
to be
stuff,
set at
how
that
about
point.
we
Mr. Beard,
look
you'll
at the
remain in
document,
contact with
look
the
at the
counsel,
docket,
so
actually.
that way you are aware of when any trial date is reset.
I'll keep an
If you
eye
have any
on
questions, sir.
the hearing to
That
see when he
concludes
gets
your
to
appearance. Have a good day.
this case. But let's see.
Let's move on to Shanika Butler-Geary.
Let's take a quick look. Here we go. So this is the docket for the case. Just see if there's anything new this morning that came up. Scroll all the way down to the bottom. Here we go. An order on defendant's motion in limine. A couple days ago, an order on state's motion in limine. Let's take a look at this defendant's motion in limine. Oh, these are the statements made to Jeff Lacasse. These are statements made to Jeff Lacasse. Specifically, 1, Charles Adelson told Wendy Adelson that buying her a television was cheaper than hiring a hitman. 2, Charles Adelson told Wendy Adelson that he looked into the possibility of hiring a hitman to address the Markel problem. 3, Charles Adelson characterized dinner he and Wendy Adelson shared following the murder as a celebration. And 4, Charles Adelson said that he kept large amounts of cash in his home. So Rashbaum argued that the 4 statements were hearsay within hearsay, with no exceptions. They do not want those statements coming into the trial against Donna Adelson. Let's scroll down to the bottom to see. Okay. So they took each statement individually. Let's see the rationale. Back up here. Okay. Part 3 of the subject system. Okay, so it looks like basically they're saying, as such, before the state may inquire as to any of those four statements, it has to first establish that a hearsay exception applies to each of the statements, or that they're just not hearsay. For those Adelson to Adelson statements that the state can establish are admissible, it may impeach Wendy Adelson through Jeff Lacasse if proper grounds for impeachment is present. Any Adelson to Adelson statement for which the state is unable to establish admissibility may not be inquired upon, as it would be hearsay for which no exception applies. The court will determine whether these statements are admissible once the state seeks to inquire about them. So it looks like they're just kind of pushing it off until the actual trial, at which point the court will ask how the statements are admissible, whether there are exceptions to hearsay, or maybe the statements just aren't coming in as hearsay at all. Maybe they're just coming in to impeach Wendy or some other individual. Let's check back real quick, see what's going on here.
Cost for the refusal, and then a misdemeanor for the DUI.
Yeah, it's still
12 months
other
probation,
cases.
Standard DUI conditions.
Was this offer conveyed to your client
It has
and the offer is rejected?
at this time.
Is that
Mr.
Georgia
Dill,
in
please
the
raise your right hand,
beige
sir, so
suit?
you can be sworn. Do you swear or affirm the testimony
No,
you will give
Georgia's
today
hair
will be
isn't
the
that
truth?
long.
You can lower your hand. Please stand in front of the microphone.
It's Sarah Dugan
so your
is
voice
there.
can be properly heard. Mr. Dill, do you understand the
In the
state's
navy suit.
final offer that has been extended?
Yes, sir.
You are rejecting this offer.
Yes, sir.
Do you need any clarification from your attorney concerning this offer?
No, sir.
Do you wish for your counsel to make a counteroffer to the state to resolve this matter?
No, sir.
Very well. This matter will remain on the trial docket as well. I believe because this case is from this year and Mr. Dill.
So it looks like there's a few cases on the judge's docket this morning.
Tried momentarily. Please take a seat for now.
Thank you, Your Honor.
Damian Donahue. Not for a few minutes, and then we'll come back to Mr. Donahue. Dwight English.
Judge, I believe you signed an order continuing this for plea hearing.
I believe so as well.
It's going to be a DPA.
Yes.
And I did waive Mr. English's presence. He was at state. We have to mail that.
Hi, Janet. Good morning. Janet's asking whether statements of co-conspirators in a crime are exceptions.
Continued as well.
Well, the
Saw Mr.
order
Williams moving around. Mr.
does
Williams.
address that. Let's look at that again real quick while they're still moving on other matters. So here it says section 90.803 18E of Florida statute provides a hearsay exception for statements offered against a party, quote, by a person who was a co-conspirator of the party during the course and in furtherance of the conspiracy. For the exception to apply, the state must establish, one, both the person making the statement and the person against whom it is offered are members of a conspiracy. Two, the statement was made during the course of the conspiracy. And three, the statement was made in furtherance of the conspiracy. So they have to show all three elements. In addition, the threshold condition of admissibility of a co-conspirator statement is whether evidence exists independent of the statement that the defendant and the declarant participated together in a conspiracy. So we need some outside extrinsic evidence other than those statements showing that they were in a conspiracy together. That's a good question, though. I'm not sure what's going on with the feed. Hi, Carol. Good morning. Good morning. Carol's watching from Australia. What time is it in Australia now? Is it tomorrow already? Friday? Or is it Thursday night? Looks like we've lost the feed from the courtroom from Law and Crime. Let me check around to see if I can find a feed from another location.
So I will rule on those matters before the trial begins.
Judge, I saw an order
I
you
think it's
you
actually
entered. I
that.
saw Mr. Stevenson's motion to eliminate when this was set for trial
Fantastic.
way back, and you did file an order
Two
denying
issues
that.
were reserved.
It also looks like
Some were ruled on, but two issues
Mentor
were
Lawyer
reserved, I believe.
at Deep Dive True
Concerning
Crime
the
is
use
going to be
of
streaming
the
this,
deep web, or
although
I
he's not
forget the
live
name of what it's
quite
called.
yet.
Thank you, sir. The use of the dark web, and I believe something
So I'll
else
keep
about
checking that one just in case this one goes
with
down again.
individuals in South America. If the parties have any additional arguments to make that were not already made, you're also entitled to pull your own copy of the recording of that hearing from that date as well.
It's 11 at night in Australia. Thanks, Carol.
To be heard before the trial
Hope you had a
starts.
nice day.
No, sir, I had a discussion about that with the client.
Of course,
And,
Deaconsella. No worries, no problem at all. I mean, I figured I was going to be watching this, so I might as well, see if we can get some friends to watch it together, right?
Before the evidence is offered by the state. And I've discussed that with the prosecutor, so there won't be any surprises there.
Good morning, Scarelli.
That is how the issue is preserved on appeal. You are well aware of
Forward
it.
your profile picture.
Very well. You remain set for next week. Mr. Hastings, that concludes your appearance for this morning.
Judge, I'm going to put on the record.
Can I ask one more thing, folks?
Go ahead.
Just to make sure we don't have any slip-ups. I've asked Mr. Hastings about court clothes, and he assured me that he has court clothes. If he doesn't, I'll go get him some, but I would just like, maybe you could inquire on that issue.
Do you have a friend or family member that can assist with this?
I do have court clothes, but I don't have a belt or a top.
I'll bring him a belt.
This defendant is talking
All right.
about
If you can tell Mr. Harrison your waist
what do you
size,
guys think
that way the
is going to be
clothes
wearing
don't look
for her trial?
weird or ill-fitting. That'll
Do we
be
think
best.
she's going to be,
Judge, I'm gonna present counsel with the notice of intent to seek a jail penalty.
you know,
And I've discussed that with the defendant, and
reading
I'm
glasses?
well aware of that. Thanks.
I don't even know.
Step over to Mr. Balboni. He will take your prints at this time.
Trying to look meek and mild.
Christian Henry, 2022 CF 3544.
Is she going to be the?
This matter was handled by written order.
I have a feeling
It
that
has already been continued, I believe, to November.
And
Steve Lincoln.
a little harmless, grandmotherly type.
Good morning, Your Honor. John Stevenson representing Steve.
Hello,
Lincoln.
Isabel.
Be ready to go.
Welcome. Isabel says she's new to the channel and really enjoys the content. Thank you so much. Thank you so much. Do I think Donna will take the stand?
Then most probably we will be doing a
Oh,
argument, and just remind
I think if she
everybody
wants to
that,
have the best chance
self-defense
for her
we are
case,
entitled
she should not take the stand.
any
But I don't know. I have a feeling Donna's going to do what Donna wants to do.
has knowledge of.
If she is, in fact,
Jacobs.
Judge, I believe Mr. Stevenson just.
if
filed this
she
motion
is,
with
in
me last night,
fact,
so I've had a
the
chance to look at it.
coordinator of the
I assume
family,
Judge
right?
Gary- or Judge
Then
Walton,
she's going to want to take charge.
assumed it would be Judge Gary would
We
be
know
the
that
one,
she's
handling the
a
motion
take
in the
charge
beginning, so
woman.
obviously I need
She
time
may have
to
been
look at it, do
behind
my own
this
research. Otherwise, the state is
all,
ready for trial.
you know? So I have a feeling
With
she
the
probably
caveat of
would
how this
want
afternoon
to
goes,
tell
I
her
will
side of the
push Gary
story.
set this afternoon.
Very well.
But
But I anticipate
we haven't seen very many
As to any matters
good
the
results
BCA
for
has previously
defendants who
ruled
end up
on,
taking
further
the
appeals
stand
today,
for
correct?
themselves
I
lately.
don't know any way I can, that they address the issue, so I'm stuck with it.
What do you guys think?
As
Maybe I should make a
jurisdiction
poll.
stacks, their
Hold
ruling
on, let me
is
see if I
their
can make a
ruling.
poll.
Act accordingly.
I don't know if I
Mr.
can.
Lincoln, you will remain on trial.
But while we're
next week
waiting,
as the oldest and most serious case.
actually, I
Your
don't think I
jury will
can
be
in StreamYard
selected
here.
on Monday morning. Do you have a friend or family member that can assist with court closing?
I'm offering court closing.
All right. Very well. As to any final offers, does the state have an offer to extend to the defendant?
Life in prison.
Mr. Lincoln, I assume you
Ms. Latner's the very last.
Ooh, what is this?
351.45.
It's the back end of something.
M-type 25.
Carol's asking if I think Rashi will advise Donna not to take the stand.
Changing for the jury.
I think he should.
Ms. Latner's, I want to turn to, is that the end of this category?
What is this? This is the YSL trial. They're getting their streams mixed up here.
very well. We remain set for trial. Are there any other issues?
I've switched over to Mentor Lawyers stream, guys.
I check to see that Mr. Lincoln will be kept around for that motion.
He will be here for the motion. Very good. Thank you, Your Honor. Mr. Lincoln, that concludes your appearance for this morning. We will pick back up with your motion hearing this afternoon.
Thank you, sir. Thank you.
Leroy McNair, 2024 CF 853.
This is going to be changes to Your Honor.
That was
Go ahead and
weird.
address it.
The Law and Crime stream switched to the YSL Rico trial.
At this time, Mr. McNair withdraws any previously entered plea of not guilty and enters a plea of no contest.
Which is, I don't know, if anybody has been following that case, that is wild. It's a wild bananas case that probably should just be dismissed in its entirety at this point.
The agreement with the state is that Mr. McNair will be adjudicated guilty as to all counts. On counts 2 and 3, sentenced to credit for time served, 26 days in the county jail.
Hey,
And on count 1, sentenced
you know
to
what?
6
You're
months
right.
of
Everything
control,
is up to
followed by 24
far
months
as
probation. He has to submit to GPS
it is her
control.
ultimate
He's not to return to any target in Leon County, and he has to pay $170 in restitution to Target.
no.
For a cost of $969.25.
Which way she's gonna go.
TV application fee
Hear
of
from you.
$50. Legal
Let's
assistance
do a poll.
$100.
Let's
and
do
cost of
one.
prosecution of $100.
Donna,
Mr. McNair is requesting 90 days from today to get started on a payment plan with the clerk.
2.
We both reviewed and signed the plea form. Mayor,
You're
Donna
right.
doesn't.
I have a moment, Judge. I don't have the amended
All right.
charge on the.
Put a 1 in the chat if you think Donna's going to testify. Put a 2 if you think she will not.
Judge, I'm gonna have to supplement the score sheet because I have it as possession with. So I'll email
I
that.
always wonder what goes through the mind.
Defense will have 5 days to review the score sheet and object if you believe it's necessary.
Also, Sarah Boone, especially for judges. Cases, you know what? They're right.
Mr. McNair, please raise your right hand, sir.
People who think
Do you
that
swear or affirm the testimony you're about to give today will be the truth?
they can sweet
You can
talk,
lower your hands.
all they have to do
Or
is
hand, I should
explain
say.
themselves
Please state your full name and give your date of birth.
once
Leroy McNair, Jr.,
inside of the story
10/21/1969.
the way that they thought about the
At
situation
this time, are you giving a no contest plea to the following charges?
to testify.
As to count
mean,
1,
is that not
an amended
Charlie?
charge of possession of cocaine, and as to counts 2 and 3,
As a talker,
petty theft, value greater than $100.
Yes, sir.
I don't
Do
know.
you understand with your plea as to these 3
She
charges,
says
you're
there's
giving up
she's
your right to have a jury trial?
Yes, sir.
Mr. McNair, did you also read and sign this acknowledgement of rights form that I'm holding up and showing to you?
Yes, sir.
Did you discuss it with Ms. Walter?
Yes, sir.
Do you have any questions for the court today concerning your legal rights?
I don't know if Donna will be as slick as what to understand. Donnie's
Are you under the influence of any alcohol, medication, or drugs?
No, sir.
I
Are you thinking clearly today?
facial
Yes, sir.
Do you understand the decision that you're making to enter into a plea?
that's
Yes, sir.
when she
Have you
first
made
told
this choice to do so of your own free will?
me at hiding
Yes,
them
sir.
at all.
Has anyone made any
Right.
threats to you or tried to coerce
Good
you
at hiding them
to
at
accept
all.
a plea today?
So unless they
Has
medicate,
anyone made any promises
or
to
she
you so
can
you would
control
accept a
herself,
plea today?
or she just doesn't have emotions,
Are you entering into this plea because you believe it is what's best for you?
it'd be very interesting.
Were you able to fully discuss the
Right.
facts of your case with your legal counsel?
I mean, it seems like the vast
Were
majority.
all questions answered?
Yes, sir.
Is there anything further that you need to discuss with Ms. Walter?
You guys are awesome.
Did
Thank
you also discuss with Ms. Walter
you.
defenses to all three charges?
Yes, sir.
Are you satisfied with her representation in this case?
Yes, sir.
You think so?
Mr. McNair, do you also understand that theft is an enhanceable offense?
She looks.
Meaning, if you're ever charged with theft in the future,
Oh, that
these pleas today can be used against you to make those future penalties worse. Does that change your mind as to what you want to do in this case?
Agile looking.
Yes, sir.
Well, does that change your mind?
That's what
No, sir. No, sir. Sorry about that.
Please listen to the question, Mr. McNair. All answers matter. Ms. Walter, do you stipulate to there being a factual basis for the plea as offered?
Yes, Your Honor.
Is there anything that you wish to raise today concerning the legality of the sentence?
Not there, I'll review the score sheet.
Very well. Again, the defense will have 5 days to review the score sheet and make any lawful objection as necessary. Mr. Fields, does the state have anything to raise as to the score sheet or legality of the sentence?
Judge, it is a lesser included offense, so I'm not going to file an amended information. The score sheet is 20.7 sentencing points.
is that her shirt?
Mr. McNair, any questions concerning what you're agreeing to or your supervision?
No, sir.
Based on your testimony today, I will accept your plea as to all three counts. I will find that it's being given freely and voluntarily, that you understand your rights and the terms and conditions of the sentence I'm going to impose.
Yes, sir.
You are adjudicated guilty as to all three counts. As to counts 2 and 3, you're sentenced to credit for time served of 26 days. On count 1, you're being placed on 6 months of community control. That will be followed by 24 months of regular probation. There will be GPS monitoring as a condition of your community control. You are not to return to any target location in Leon County. There is also $170 in restitution to be made to target.
And
Does this restitution go to the corporation, or where does it go exactly?
Judge, I'll submit an order with the address.
I know that she's going through, but
I'm not sure if it's corporate or to the individual store.
All right.
jail was not
Once
fun.
Mr. McNair makes the payment to probation, he will have satisfied his condition, but they still need to know where it needs to go.
I was asking. I don't
Court costs will be $969.25, $50 PD application fee, $100 legal assistance lien, $100 cost of prosecution.
know fresh set of
30 days to appeal if you desire to do so, Mr. McNair. You will be fingerprinted this morning, and you are to report before 5 p.m. today.
done that.
Good luck to you. Please step over the bench.
She thought,
Thank you.
he already knows the case, so he can get this to trial quickly,
Joseph Norwood,
get exonerated, acquitted.
Norwood, if you can turn on your audio and video.
I do think it was
Good
a
morning, Your Honor. Rusty Shepherd on behalf of Joseph Norwood.
like issues, but
Judge, in Mr. Norwood's case,
just ask about it.
previously continued it.
I don't know if she truly knows
We
like
have filed a motion to continue in the case. It is our
the
understanding
extent to
that the case
which
is a backup.
conflict
Mr.
can.
Norwood resides in the state of Nevada.
The best thing she
There are other reasons for the.
could have done was hire Alex Lawrence to at least
Hearing scheduled with Mr.
assist
Myers, Bobby Myers, who practiced together. And he's previously appeared on behalf of
People
Mr. Norwood.
still has
Mr. Myers is
not
scheduled to
rational.
file on Monday in State versus Taraboki, case
This is just
22-371.
trial help.
The Washington County case. And Your Honor, I am scheduled in Bay County for Jason Davies. That case is 2638 CF.
Are these cases actually going, or you're just on the docket?
Yes, sir. They're going. Yeah, they're old cases, Judge. That 20 case, that might be the oldest case in Bay County. And the other one's a 22 case, and it's as far as we can tell, it's going. He's rejected, Mr. Borkey's rejected probation. So additionally, Your Honor, we do have the logistical issues. So if the court does grant our motion to continue, we would request to be actually, as opposed to being a backup, simply because of the travel that we actually placed on the trial docket so that we make sure that we're going, so logistically we don't have to worry about the travel issues.
I think the best way to ensure that is whenever this is set again, ultimately for you to file a demand, and you will have top priority at that point. Ms. Jacobs,
That's fine, Judge. I don't have an objection. Obviously, if defense counsel isn't available, I have communicated the offer to Mr. Myers, not to Mr. Shepherd. I do want to put that on the record since the defendant is present on the Zoom, because
Go
I
ahead.
do also want to give a cutoff date to that offer at this point. The last offer that was extended to the defendant was for him to enter an open plea as charged, which is manslaughter by driving under the influence. That the state would waive his score sheet, which is 10 years in the Department of Corrections, but not the minimum mandatory, which is 4 years in the Department of Corrections. And so Your Honor would have a sentencing range of between 4 and 15 years in the Department of Corrections. The cutoff date that I'm going to give to this defendant to enter that plea is October 16th.
well,
I'm not sure that that offer has been conveyed to Mr. Norwood. I think that maybe that's a very recent offer.
I've repeatedly given it to Mr. Myers.
Maybe he
over the
has,
course
Judge.
of
My
months.
apologies.
So I don't know if it's been communicated to the client, because obviously I'm not allowed to talk to him, but I've given it to Mr. Myers multiple times.
Mr. Norwood, were you able to clearly hear Ms. Jacobs when she conveyed the offer?
Yes, sir.
You will have some additional time to discuss the offer with your attorneys in private, but I wanted to make sure you are aware of it, and you're also aware of the cutoff date, which again would be 10/16, Ms. Jacobs.
Yes, Your Honor.
Very well. This matter will be reset to docket sounding on October 17th for the trial week of October 21. To ensure that you are in fact going as requested, the defense should file a demand for speedy trial. And at that point, there will be no question.
10-4. Thank you, sir. Appreciate you.
Have a good day, Mr. Norwood. You are excused.
Thank you, Your Honor. That concludes my business.
Karina Robinson.
Oh,
Good morning, Ms. Robinson.
Morning.
Ms. Robinson, at all critical stages, the court will offer you court-appointed counsel once again. Through a Feretta hearing, you are representing yourself. As I found, you voluntarily waived and intelligently waived your right to court-appointed counsel. Do you wish to have court-appointed counsel appointed to you once again?
No, sir.
Very well. You will continue to represent yourself. I will rely on all findings and representations that were previously made at the
Hey,
Feretta
Carol.
hearing. Ms. Robinson,
is
are you
my audio
prepared to
not
go to trial?
okay? I lost the law and crime stream. They jumped to my sole trial, and it looks like they're
pending a DCF
going
mental
to
health eval, and we'd like to see the results of that before we can pay up.
maybe play the hearing at 10
She
o'clock.
previously offered diversion on this matter.
Maybe they
She's
saw
previously
that
offered a
all these
DPA and denied it.
first.
I don't think there's anything else to
No.
offer.
Well, we revoked it and we are considering.
We got another vote.
DPA
Got
once
it.
again, if the mental health shows us differently.
Very well. Ms. Robinson, do you understand what the state is asking for?
Yes, sir.
Very well. I will continue this matter. What date are you asking for in October?
Yes, Your Honor, docket sounding 10/17, I believe.
October 17th, docket sounding, week of trial would be 10/21. Ms. Robinson, you are to appear in person once again. Have a good day. Tedrick Saylor, demand for speedy trial, 2024 CF 1397.
Got it.
Hey, good morning, Judge.
Good morning. What date is the defense requesting? We're still within natural speedy, are we not?
Honestly, I'm not sure. I filed the demand. I think we are.
I feel like I felt this shift in the community like the past week, almost like Donna is a given where, yeah, she's going to be convicted, but people are really out for vengeance against Wendy Adelson, right? Like, if we had our choice, Donna or Wendy, to convict, which one would we want convicted? I think the general consensus would be Wendy, right? So it's interesting because Judge Everett mentioned a plea deal and the time for a plea deal expiring, coming up quickly. And I'm just wondering if anything has been offered to her at all, or if they've proposed anything. Curious about that.
My system is showing 1, and then the 11/4 trial week, I believe that still falls within the 175-day period, unless you have a different calculation, Mr. Williams.
I'd have to recalculate the 175, and to be honest, Judge, I've never been in a situation where I've demand that things actually speedy. So I don't know. The
45 days from the demand still, but
So if we're going off that date and not natural speedy, I believe, and I know we have a recapture period. I believe the recapture period is now 30 days. But I'm calculating, the case needs to be set before the
Hold on,
second.
let me pause this. Isabel's saying she's honestly on the fence with Wendy personally. I think she knew about it and complained, but wasn't in on the planning. What do you guys think about this? I think it's possible that she goaded them into doing something, anything. Maybe she didn't know the exact details. I don't know. But they got the information about Dan's schedule from someone. And who would they have gotten it from? Who is the only person that they would have gotten that information from? You know? You really think, Isabel, that she unknowingly provided them information about Dan's schedule, his comings and goings? I don't know. I don't know. Veronica's saying, Isabel, you must be alone in that. We all know it was Wendy who planted this. Yeah, planted this on everyone's head. She told them Dan was leaving. She's the master planner. A lot of people believe in Santa Claus still. Hey. Exactly, Judy. I think that's a big part of it. That's a big part of it. These hitmen weren't looking up Dan's address and his picture, his address. They weren't going to Prof's Law blog. Are you kidding me? One who is high 24/7, drunk and high. They're both on coke. One of them is illiterate. He can't even read. You really think that he's going to go to the blog by himself? As Louis said, Wendy is the blog. Wendy's the blog.
So if to the
This delay is kind of typical, you guys. Judges will usually go through the shorter hearings.
joint motion to continue is granted. The next court date for Mr. White will be October 15th at 9 o'clock in the morning. Any trial date to be reset at
Judges will usually go through the shorter hearings first, get them out of the way, clear out the courtroom, and wait until after those are resolved to get to the longer, more substantive issues on the docket. So I'm not really surprised that this is taking so long.
that point.
Your Honor, the defense is ready to proceed to trial. I know that Mr. Fields mentioned previously, before Mr. Dawkins was present on Zoom, that his understanding was that the court had ordered today to be a mandatory in-person appearance. I don't have any recollection of that. That is not what I advised Mr. Dawkins. It's not reflected in the clerk notes from his last court date.
On the first,
So that's why he's present on Zoom.
I
also,
remember the fingerprints were an issue that were discussed, but Mr. Dawkins also was dealing with a COVID diagnosis,
Yes, Your Honor.
in which that's why the trial could not proceed last week. Mr. Dawkins, you are going to have to be present come Monday morning. You are going to be one of the cases set for trial. At that time on Monday, one moment, at that time on Monday, your fingerprints are going to be rolled unless there is a lawful objection.
And
Ms.
I have no
Walter?
objection, Your
let me get to some more of these comments. Carol says, I do not believe that Wendy's family would murder the father of Wendy's children without Wendy giving her okay. That's a good point. That's a good point. That is a very final and permanent decision, right? That has huge ramifications on all of them, but mostly Wendy and her sons, their own grandchildren. Isabel say, I think it wasn't unknowingly, but she knew her family would take care of it, and she was more like, do something but leave me out of this. And Veronica's agreeing with Carol. Isabel's arguing her case, man. I think if the case on Wendy was so easy and clear, they would have already charged / indicted her. I don't know if I necessarily agree with that. We saw how long it's taken to get to Charlie and to Donna. I mean, it's been years already. So there's a method to the madness. Of course, there were some political things that we know were going on in the past, in the interim. But I don't think it's as clear cut as we don't have any evidence against her. So that's why we're not charging her, indicting her for 10 years. I have to disagree with you on that one, Isabel. But her possibly saying, take care of it, but leave me out of this. I don't know. That's maybe. I don't really believe it, but if you're going to play the devil's advocate, that's maybe a possibility. You know how Wendy says, I don't talk to my family about anything. I haven't reviewed this case at all. I haven't looked at anything. Lies. I don't believe that, and I don't think anybody believes that. But she does seem to like to dig her head in the sand. The ostrich defense, right? It's no real defense. Let's see where they're at.
Your Honor.
Very well, Mr. Fields.
Oh, Georgia's.
The state loses work something out, I don't have any problem with that, but I don't have any problem with state denying anything.
This is to be settled, Mr. Dawkins, between your counsel and the state, if there's going to be any resuming of a plea negotiation. Please appear on Monday at 8:30 in courtroom 3B. Be prepared to go to trial. Have a good day. Danny Donahue.
Wow. All kinds of issues. It looks like Mentor Lawyer has two different cameras or two different setups. Oh, no. Wow, they're having all kinds of issues this morning. Well, let's get back to some of the chats. Some of these comments. Veronica is saying, Isabel, you must be new to this case. I've followed it for years, and it's clear Wendy stood to benefit the most and knew how to manipulate her family. We do believe that Wendy stood to benefit the most, despite her saying on her cross-examination with Daniel Rashbaum in Charlie's trial, all these things that he mentioned. He mentioned she gets to move to the city that she wants to be in. She no longer has to be in Tallahassee, the locale that she detests. She gets to be around her family again. She gets that support and, just the familial bonds being so close. Her family doesn't have to travel all the time. You guys, you remember when Wendy stood up on the stand and she said, that's no benefit. Like, really? I think the jury can see right through her. And and we see through right through her as well, right? I need some more coffee, you guys. And Wendy knew how to manipulate her family. We heard in those wires that Donna and Charlie saying how we've always protected Wendy. She was kind of the golden child, the princess of the family. I forget who I was listening to. It may have been maybe Patty yesterday, where where she was saying the poor boys, the poor sons in the family. Like you have Rob, who's estranged and just doesn't even speak with or communicate with the family, and you have Charlie, who just begs for his mother's attention because all that attention has been on Wendy all her life. So we think that, Wendy has everybody wrapped around her little fingers. In fact, I think is the only decent defense Donna has to say Wendy brainwashed them all. And Veronica, do you think that would actually happen? I don't see that happening. That would mean they would have to throw Wendy under the bus. And I I hesitate to think that that would happen in the trial. I really don't think so. Judy's saying, I feel that Wendy's part was far more controlling and underhanded. She knew how to manipulate her family and was smart enough to insulate herself. That's what makes the case against her so difficult. Yeah. Carol's asking, do I know Georgia? No. Georgia doesn't know me either, right? The last hearing when Judge Everett gave me a shout out, I like to think that it was a shout out. It was just because I had logged into the Zoom stream because I didn't know if it would be streamed on YouTube. So I logged into the Zoom and he was asking who the different people in the Zoom are. So he was like, and Miss Kappelman, do you know who Miss Janice is? And Georgia was like, nope. I like to think that it was a shout out from Judge Everett.
3226.
Yeah, guys.
Mrs. Adelson, you can go ahead and take a seat at council table.
Let's go. I can't wait to hear what Sarah Yusuf has to say as well. Former friend, ex-friend of Wendy Adelson. I have a feeling she has some good stories.
In addition to the normal docket sounding business to address, we have the motion filed by attorney David Marcus to quash a subpoena by the defense. And we also have the matter that we need to finish on Sergeant Corbett's testimony. Did everyone receive their copy of the order on the defense's motion in limine yesterday?
Yes, sir.
Yes, Your Honor.
Very well. You may make your notices of appearance.
Georgia Kappelman for the state. Sir Kappelman Vivian for the state.
Dan Rashbaum on behalf of Ms. Adelson.
Alex Morris on behalf of the state.
Right, Mr. Marcus, I will be with you momentarily. Concerning our docket sounding this morning, let's go ahead and address that. Does the state have any issues that they need to raise at this time?
No, Your Honor, the state's ready.
Has the state extended a final offer to the defendant?
No, Your Honor.
Very well. Mr. Morris, Mr. Rashbaum, Does your client have a counter offer that she wishes to extend to the state at this time?
No, Your Honor.
Mrs. Adelson, if you please can rise and raise your right hand.
Interesting.
Please, do you swear or affirm the testimony
No.
you're about to give will be the truth? You can lower your hand. Mrs. Adelson, is there any counter offer that you wish for your attorneys to extend to the state before we proceed further in this matter? Very well. You may be seated.
Wow.
Is there any issue the defense needs to raise moving into next week?
No, Your Honor.
Then let's go ahead and address Mr. Marcus's motion to quash the defense subpoena. Mr. Marcus, good morning, sir.
Good morning, Your Honor. Nice to see you.
You as well.
Guys.
I have reviewed your pleading. What is the defense's position concerning the trial testimony subpoena?
Judge, the defense doesn't seek to elicit any testimony related to Mr. Marcus's attorney-client protected conversations with his client. There are three categories that the state seeks, the defense seeks Mr. Marcus's testimony. The first is the state's indicated and they reaffirmed to Your Honor that they intend to ask investigator Isom whether or not Mr. Marcus called immediately after Katie McManua was arrested. The jury, if left there, the jury takes away that someone or somehow the defendants are all in cahoots, if you will. The defense believes that Mr. Marcus would testify that that is not the case at all, and he would provide information as to how it was that he received information about Ms. McManua's arrest and how he knew to call investigator Isom. That's the first category. The second one is the state has investigated vigorously to try to pinpoint that the Adelson family has provided legal fees for other lawyers or other co-defendants in the case. I don't know whether the state seeks to elicit testimony of that nature, but as recent as January of this year, the FBI was down in Miami speaking with Mr. Marcus about such things. Mr. Marcus provides an explanation that doesn't involve attorney-client privilege. That didn't happen. Mr. Marcus made a suggestion of the potential legal strategies involved, but nothing ever came to fruition, and there were no discussions with any co-defendants or the Adelsons. And then the third category, Judge, is there's a text message between Mr. Marcus and his client, Charlie Adelson, at the time, about him having seen or bumped into Katie McManua outside of his office, and there's a comment about something to the extent of it being a coincidence, but there was no conversation that was had. Again, if the state elicits that testimony in all three of those categories and it's left hanging, it goes unanswered. But in each circumstance, Mr. Marcus is able to respond, and I don't believe that it invades the attorney-client privilege.
Mr. Marcus, I'll allow you to respond to what the defense is proffering and why they would seek your testimony.
Thank you, Your Honor. And so I'll take the easiest one first, which is the last one. I had not heard about this text message between me and my former client, but that would obviously be privileged. And so any testimony regarding a text message between me and Charlie Adelson, I would not be able to comment on. So that I think is the easiest one. Let me take the other two.
Let me ask you one question before you continue. Mr. Adelson has not waived any privilege with regard to you.
Correct.
You may continue.
Thank you. Yes, I have not been informed that he's waived any privilege by him or anyone else. The other two categories, and I'm sorry for not looking over that, kind of looking at my notes here, Your Honor, but the first is the call to Detective Isom. So I guess I just don't understand how the state putting in this evidence is relevant, and therefore the underlying evidence in my response to it, I think, should be suppressed. The idea that on the morning that Katie McManua was arrested, I learned of that arrest and called the detective to find out if Charlie Adelson was being arrested. There's nothing wrong with that. That's what any good lawyer would do. The defense is right that I would respond to any nefarious suggestion by the state that there's nothing wrong with me calling the detective to find out if Charlie was being arrested that morning. But I guess my response I don't think that initial evidence should be able to come in, and I made a phone call to the detective to inquire about Charlie. Certainly that has nothing to do with Donna Adelson. And even if this was a trial about Charlie Adelson, I don't think it would be relevant, Your Honor. I was trying to find out whether the detective that morning was going to arrest Charlie. Nothing's wrong, nothing untoward or abnormal about me calling the detective to inquire about it. I would ask that whole little snippet be excluded, the underlying evidence and what my response would be to it. The final thing about legal fees, I addressed this in my motion. I've spoken to the state about it, so I don't think they're going to elicit anything about this. They released me from my subpoena on this issue, so I'm not sure that the defense needs me to rebut anything because my understanding from speaking to the state is they don't intend to elicit anything on that issue.
Ms. Kappelman, Ms. Dugan, are you seeking to elicit any information or evidence during the trial that would concern Mr. Marcus?
Potentially, yes, Your Honor. We are seeking to introduce the evidence that I mentioned previously at our last hearing about the call to ISOM.
And the relevance hook of this would be it goes to your conspiracy theory or what exactly?
Yes, sir. Exactly. Would I get into anything about the offer from Mr. Marcus to Catherine McManus attorneys to pay her attorney's fees on behalf of the Adelsons? Potentially, yes.
Yep.
What's the third question?
I believe the last matter was any text message between Mr. Marcus and Charles Adelson when he was representing him.
Yeah, I think that the defense has mischaracterized that evidence, but that is a piece that could potentially be inquired about as well.
Mm-hmm.
All right. As to the first issue of the phone call and whether it goes in any form or fashion to the conspiracy, what I'm going to rule is the following. The state may inquire as to the topic. If the defense has a factual related line of questioning to ask Mr. Marcus, the factual line of questioning will be permitted. Nothing that goes into attorney-client privilege may be inquired to. Is everyone clear on this?
Yes.
Very well. As to the second line of questioning, again, Ms. Kappelman, this is being offered for what exactly concerning any possible agreement or payment?
Yes, same relevance argument here when it goes to conspiracy, the existence of the conspiracy.
Right. As to this, were the defendants, well, I believe the privilege argument gets a little more thorny at this point. What exactly can Mr. Marcus offer that would not be privileged on this issue?
Are you inquiring of me, Judge?
Either party.
My understanding, and Mr. Marcus can correct me where I'm wrong, is that there was a conversation with Katie McManus' counsel. I don't believe that Mr. Marcus conferred with his client, but it's something that he does in his normal practices, which a lot of lawyers do, myself included, call co-defendants counsel. If there's a necessity of sharing expenses, I think it was his suggestion, and just that, his suggestion versus the Adelsons.
What?
Marcus, is there any argument as to why this is privileged specifically?
No, Your Honor, if I'm asked the privilege question on the stand, of course, I'll just invoke it at that point. I have no problem doing that, Your Honor. And, Your Honor, if I could just be heard for 1 second.
Go ahead.
There is, of course, a difference with the state arguing the existence of a conspiracy and crazy conspiracy theories. There is no basis to argue the existence of a conspiracy by my calling the detective to find out whether Charlie Adelson was being arrested that morning. There's just no, they have to at least allege some tie, some basis, in fact, to argue that there was a conspiracy that would have some relevance in this trial. I was calling to find out from the detective whether he was arresting my client that morning. There's nothing tied to any conspiracy, certainly, with Donna Adelson. So it's just a conspiracy theory with no basis in fact, Your Honor.
I fully fully understand where you're coming from with both your pleading and your position this morning. As a factual issue, did the phone call take place? There is nothing protected concerning that. How that fits into the larger narrative of what may be admissible or not, yet to be determined. The state, they have their fair opportunity to put on their case. If further objection needs to be raised at that time, I will address at the time. But as to the pure factual issue and whether or not you have knowledge on that topic, that does not go to privilege. That is where they will be permitted to inquire. That is where the defense will be permitted to rebut. Nothing more, nothing further. To the second issue of the offering of fees, is there any privilege that you can assert concerning this, or this was just an idea between you to the other attorneys?
Latter.
As to that topic, factually, it may be inquired into. How this again fits into the larger leaving of the evidence. If there needs to be an objection at that time, it may be raised, but on the pure factual issue, state may inquire, defense may rebut. As to the third issue of the text message between attorney and Mr. Marcus and Mr. Adelson.
I have my facts wrong on that, Judge. I'm sorry for interrupting. The message is actually, Mr. Marcus spoke with Mr. Adelson. Mr. Adelson then communicated with his mother that he had spoken with Mr. Marcus, and Mr. Marcus had indicated that he had bumped into Miss McManus. So my sequence of events a little off.
What?
And the state would be seeking to offer this also under the same conspiracy theory.
Yes, Your Honor.
Right? Mr. Marcus, are you alleging or asserting at this point that a privileged matter was discussed through that text message?
I don't know what text message they're referring to, Your Honor. I have not seen it, but if they're referring at all to a text message between me and my client, of course, that would be privileged. If I'm hearing Mr. Morris right, he's now referring to a text message between Charlie Adelson and Donna Adelson. I don't know whether that would be privileged or not. I doubt it, but I don't have any, that's not between me and my client and my former client.
Was this a communication that was captured through the wiretap?
No, sir. It's part of what was captured off of the devices that were searched.
So this was a text message from Mr. Adelson to Mrs. Adelson.
That's correct, Your Honor.
All right. As to that, Mr. Marcus, if it does not include any advice or opinions that you're providing to your client, if there was no joint defense agreement concerning them, ultimately this can be argued as a communication between co-conspirators. It just merely mentions your name, if I'm understanding this correctly. Is there any correction as that needs to be given on this point? Okay.
No, Your Honor.
Very well. As to that, the state may inquire as to the communication, as to anything that Mr. Marcus discussed with Mr. Adelson that may not be inquired into, but the substance of the text message, if the state in some way is going to argue this goes to conspiracy, they'll be given an opportunity to do so. If an objection needs to be raised, you may do so contemporaneously during the trial itself. So Mr. Marcus has a better opportunity to plan. The parties know when he would actually need to testify. I'm sure he has a very busy schedule, and we're not trying to create a hardship or inconvenience as it relates to his work and business.
As soon as the state rests, the defense intends on calling him.
Right, I believe your previous estimate, Ms. Kappelman, was 6 or 7 days.
Yes, sir.
Let's pinpoint on the calendar then at least a projection that will assist the witness in determining when he would need to be present. Jury selection begins next week on the 17th. If we have a jury by Thursday the 19th, the first day of trial would be Friday the 20th. And that means by Friday the 27th, potentially the state is resting its case, which would lead us then to Monday the 30th, the beginning of the defense case. unless I'm off of my calculations.
You're correct, Your Honor.
You're correct. And the defense has a bit of a time pressure also because of the Jewish holidays.
Mr. Marcus, if you can go ahead then and mark on your calendar as to when you may potentially be called, starting with September 30th. If there is any hardship that you need to address in other cases or matters that you're involved with, please let the parties know. If it's another state court matter, perhaps I can pick up the phone, free you up.
Thank you, Your Honor. I am doing federal court on the first, but I'll work with the parties to see if I can get called on the 30th if it's actually going to happen. I suspect, Your Honor, that when the factual issues come up in trial, that there will be some debate about whether these items should come in because, again, I'm not as plugged in as everybody here, but it just seems that the three topics don't go to any actual conspiracy theory, but I'm hoping that when the objections are raised, they may obviate my need to come on the 30th.
All right. That concludes the motion to quash the subpoena. Have a good day, sir.
Thank you, Your Honor.
Well, defense needs to throw anything at the wall and see what sticks.
Let's continue next with the continuation of the motion on the summary. Is Sergeant Corbett present?
Should be judged on me.
So now it looks like we're going to hear from Sergeant Corbett.
And also, so the record is clear on this matter, the motion to quash the trial subpoena is denied as to all factual issues in which Mr. Marcus would have personal knowledge and can testify relevantly.
I just sent him a message. I'm sure he's probably parking or on the elevator or something like that. We do have another part of the motion. If you want, we can take up in the meantime.
Sure.
They had objections to specific parts of the presentation as to hearsay and attorney-client joint defense privilege. We could go ahead and take those up now.
Go ahead.
Mayor First, Your Honor.
You may.
Judge, it's changing the document, so it's based on what I have so far. So there may be more that comes up in trial, but based on what I have right now.
You've reviewed it all, correct?
What's that?
You've reviewed all of it.
I've reviewed all that we have as of now.
Right, go ahead.
So I think it's page 20. It's an email between Donna Adelson and Renee Griggs. And below it, it's in response to an email from Renee Griggs to Donna Adelson. It's hearsay.
What is this being offered for?
Judge, in that email, the defendant explains that she is stressed about her daughter not being able to relocate. That her daughter, I think, doesn't realize how much it will affect her life, Donna Adelson's life, their whole family's life if this doesn't happen. The comments from the counselor that are concerned about her stress levels, I think, just add context. That's what we would be asking for the holding all to be admissible for. And it's
So
also,
you're not offering it for the truth of the matter asserted, or you're offering it as a party opponent admission of some sort?
Yes, we're offering Donna Adelson's comments as admission by a party opponent, also a statement against interest about how stressed she is about her daughter not being able to relocate and how much it will affect her family if it doesn't happen. The therapist, or not therapist, life coach's comments that are also contained in the email would only be there for context.
Very well. As to that point, Ms. Rauschbaum, I will permit slide 20 if there is any limiting instruction that you wish to give concerning Mrs. Griggs' responses as only providing context to what the admission may be. That would be appropriate. But if these are party opponent admissions, they are permitted.
Judge, may I briefly just respond and be heard?
Go ahead.
The problem isn't Donna Adelson's comments. We don't have a problem with that. Those are statements against interest. And they're not confusing at all. They say exactly what they just said. The problem is Renee Griggs' email to Donna Adelson, which is hearsay. It doesn't give any additional context to what she said. You can understand Donna Adelson's admissions by her email alone.
So you're saying part then of this is just a response from Griggs to your client?
No, it's a chain, right? So it's a chain of emails between the two of them. We have no issues with Donna's part of the chain coming in. The problem is Renee Griggs' chain doesn't, it's not confusing what Donna's saying. I can read it to you. She says exactly what they just said. So if you never heard what Griggs says, she says, I'm stressed about my son, but honestly, I'm more stressed about Wendy and what will happen if she doesn't get relocation at the June hearing. Her life will change drastically if she has to remain in Tallahassee, and so will ours, and not in a good way. But I'll tell you more about it when we talk.
Wow.
If your mother is doing better or at least stable, Donna. So if you just allow that in, which we don't have an objection to, that's a statement that Donna Adelson's making, you're okay. But
does Griggs respond from there? Does your client respond from the response?
No, Griggs doesn't respond from there, but Griggs' email below is, hi Donna, I'm not sure, and I only have part of it, but I'm not sure if you're back from your trip yet or not. I planned to check in yesterday. However, my mom was in the hospital and I was handling family stuff, so I was a bit out of pocket. More than anything else, I want to see how you're doing. It seems as though you have a great deal of weight on your shoulders. I could both hear and feel it on our phone conversation the other day. I'd really like to be able to help you shed whatever it is that feels so heavy. Please know I'm thinking of you and looking forward to our work together whenever you're ready. Take good care, Renee. I don't see how that isn't blatant hearsay without any exception. It doesn't, you understand again, the relevance that they just put it in for is exactly what Donna Adelson's email says, which we don't have a problem with that piece of it.
Dugan, what exactly context is being provided by Mrs. Griggs' first email before Ms. Adelson responds?
So the defense, I think, accidentally, when they read about, yes, I'm stressed about my son and my daughter, she doesn't get relocation and how all our lives have changed drastically. That was Donna Adelson's email. The last email he read was from Ms. Griggs. In that email from Ms. Griggs, who's the life coach, she basically is just saying, I'm checking in on you. You seem last time to have a great deal of weight on your shoulders. I'd like to help you. And that's when Donna Adelson talks about how stressed she is and how much her life will change drastically. So I think that the life coach's email just gives Ms. Adelson's comments a little bit of context as far as explaining why she's kind of pouring her heart out there and explaining why she's been so upset.
How much further does this chain go beyond?
I'm not seeking anything more than this page. I think there is more of this chain, but this is the only page I'd be asking for.
I'll reserve ruling on this from now. I'll look at it again when I have my thumb drive and can review the slide in its entirety. Go ahead.
I don't think they need it.
Judge, I think the next item we have, I think we've got new slides on this, but I'll go, I think for ease, we'll go on the slides that you have, because it's the same issue. If you go, it's slides 255. We don't actually have new slides on this, I apologize. It's slide 255, where Agent Corbett is estimating how long travel takes. We're moving to exclude that based on speculation.
Good morning, Lou.
Sergeant Corbett do any calculation or in some other way develop this information that can be demonstrated as reliable?
Yes, sir. So on this slide, we have actual versus optimal travel of Wendy Adelson on the day of the crime. The actual travel is based on the events in her call detail records, where it shows cell towers that her phone is communicating with as she leaves her house and goes on her way that day from by the crime scene to ABC liquor store and up to lunch. That's based on call detail records. And also other evidence like an ABC receipt that she had that day. For the red dotted line, that's the summary of the shortest route. So if we're saying this is the actual route versus the shortest route she could have taken from point A to point B, her home to where another liquor store is in the restaurant. What he uses to show travel time or miles is a company called, or a mapping company called Esri, which is, and if you need to hear more about it from Sergeant Corbett, he'll be here in just a second. But basically that is a software that Florida Department of Transportation uses for their mapping and mileage calculations. He uses this very regularly in all of his mapping and travel calculations in all of his presentations. And he knows it's reliable because several times he's tested it himself. He looks at where the map says the travel time should be in the miles, and he does the drive himself. So he's been able to personally test this several times, and it's been accurate. And what we have in this slide is, one is call records, the other is the summary of the shortest route, and it's literally just saying, hey, this is point A, this is point B, and this is the mileage according to Esri, and this is the minutes it should take. And it's twice as long as the actual, or twice as short as the actual route.
All right. The sergeant also will be able to testify as to his knowledge of this program, its use, and the fact that he is qualified to use this program.
Yes, sir, and I can ask him those questions today if you'd like me to, but he regularly uses this program and has knowledge of it, is qualified to talk about it, and has had personal knowledge of testing its accuracy before.
All right. On this issue, Mr. Rauschbaum, you're essentially objecting that either the sergeant does not have an accurate calculation or in some way misuses the program. What exactly are you getting at?
May I have one moment, Your Honor?
Go ahead.
I need to know why we don't want this in. What's our basis, Alex?
Judge, the objection isn't as to his knowledge, and you know what, we'll withdraw the objection.
Very well.
Rather cross.
Here we go. The map will be in.
Judge, the next one, and let me just confer with my co-counsel for 1 second.
Go ahead.
So defense is going through the individual exhibits that are in the PowerPoint that in the last hearing, they were arguing these things are not admissible. Remember, the state has a 300-odd page PowerPoint. Defense doesn't want some of the individual documents within that PowerPoint to be introduced at trial. So
Judge, the next one is page 318. Some messages between Charlie Adelson and Donna Adelson. Charlie Adelson's messages are hearsay, and they're not in furtherance of the conspiracy.
this is
Yes, sir.
I could just give you the date of the messages too. The
Sure.
date is August 2nd, 2016, which is after the arrests of Sigfredo Garcia and Luis Rivera.
Stugan.
In the motion, defense also objected to this on the basis of joint defense privilege. Is that no longer being argued?
It's not that. The document we objected to on behalf of joint defense privilege is hold on, let me just double check. Is a different one, and we're going to withdraw that objection given the court's ruling earlier today.
Okay.
This doesn't have to do with that because it doesn't mention
This
Mr.
is just
Marquez.
hearsay. Okay.
This is just hearsay.
All right, so Judge, on page 318, what we have are co-conspirator statements. This text message it says, This is from August of 2016, so this is going to be after the arrest of Garcia and Rivera.
Ooh, let's hear what this
It
says.
says, from Charlie Adelson to Donna Adelson. Did you see in the paper where the state star witness that rented the hotel room is a convicted cocaine dealer? Maybe those guys were just up in Tallahassee buying drugs, and just in the wrong place at the wrong time. Maybe the coke dealer did it because Danny didn't pay for his drugs, just like he stiffed everybody else he did business with. This
Wow.
whole thing is just crazy. Then Donna Adelson goes on to say, I didn't see which paper. Charlie Adelson says, Tallahassee Democrat. Miss Adelson says, wow, I stopped reading everything. Charlie Adelson says, the guy admitted to selling them cocaine and hanging out with them. And Donna Adelson says, OMG, exclamation point. Our argument would be that this is co-conspirator statements. This
Wow.
is nothing more than co-conspirators celebrating another possible explanation that does not involve them for this crime. They are theorizing about another possible explanation for Dan Martell's murder. And this is showing just their theorizing and celebration of something that doesn't involve them that could explain the murder.
Wow.
Any response?
I don't understand it. I mean, it is, I mean, I can show you the text messages in its entirety if you would like me to bring it up, but that's not what happened. I don't even.
I'll review it with my thumb drive as well when I go through slide deck. The problem, Ms. Dugan, that I'm drawing with this, the communications do not have to be so overt as to saying, you know, we're hiding the gun here or something of that nature. But them essentially mocking, I guess, the drug dealer or the fact that someone else has been arrested in furtherance of their conspiracy. I guess flesh that one out for me a little bit more.
Well, also, I mean, their defense is that they were extorted, and this message pushes back on that. At the time this text was sent,
Don't
Garcia
speak over each other.
Thank you.
and Rivera had been arrested already. So Donna and Charlie Adelson would have known the people behind Dan Martell's murder. And now those people are behind bars. And now, so why, if they've been extorted by these people for the past several years, why are they theorizing about another possible explanation for this murder? They know what happened to him. Those people have been extorting them for years, and they're arrested. Why are they now trying to say maybe he was killed by a cocaine dealer for stiffing him? Why are they theorizing and celebrating something that doesn't involve him?
All right, so I follow your logic. You're not offering this for truth of the matter asserted, but rather to rebut any theory the defense is planning to present about a extortion conspiracy of some sort.
Right. Yeah, I'm not offering it to show that the state star witness was a cocaine dealer. Maybe Dan Martell was killed by a cocaine dealer, or that's what Charlie Adelson actually thought. It's to push back on extortion.
As to the basis of which it's being offered, Mr. Rauschbaum, what is your argument?
The key is you got to look, and I'm happy to hand it up to you. You have to look at what Donna Adelson says. She doesn't say any of that. She's asking what paper, and I don't know what you're talking about.
Co-conspirator
So
statement.
Charlie Adelson's statements after the conspiracy, the alleged conspiracy, after the arrest, after the murder, and Donna Adelson doesn't respond in any way to what he's saying. She doesn't have a clue what he's talking about.
As to this slide, I'm going to reserve for now. I cannot ask you to show your defense or what you plan to argue, but ultimately, if any way, if it comes down to your client was relying on statements of Charlie Adelson in some way concerning her behaviors and how she conducted herself and whether she in fact knew of the extortion, the state plans to rebut the extortion theory of defense. It is permissible as to that basis, but not for the truth of the matter asserted. If a limiting instruction needs to be given, it will be given as to that specific slide. You may continue.
The next one, Your Honor, I don't have a page number. Let me see if I can figure it out. I think it's 321. It's very small writing, and it involves text messages between Donna Adelson and Wendy Adelson after Charlie Adelson's conviction. Again, the text messages by Donna Adelson are fair game, but the text messages by Wendy Adelson are hearsay.
Stop trying to protect Wendy.
And the timing of it is critical. It's after the verdict. It's actually the hours after the verdict in Charlie Adelson's case. So I'm not sure how it could be in furtherance of the conspiracy.
So,
So I think that and we may be able to come to an agreement on this. I think that I'm going to, there's several messages between Wendy Adelson and Donna Adelson in this chain. I would only be using from when Donna Adelson says, prayer hands, you shouldn't have to pray. He's telling the truth. He protected his little sister for years. To your brother protected you for years, now you're not guilty. I wouldn't be offering anything after that. So I think the only thing Wendy Adelson says in the meantime is, I love you, call me if you can.
If that's all, then we're okay with that.
how about that?
Yep.
Let's move on.
The next one is page 324. So
We can come to an agreement on this one too.
we're on a roll here. So you're not.
Do we need me any further? Call it a day?
I'm not going to use that one in the presentation.
Okay.
I tried to give them all the things that I could possibly use and have tried to whittle it down some.
Just to be clear, that's the Cellbrite with the website pages.
I will be using the website page for the non-extradition countries, but not the motion.
Okay, we're good. That's all I have for now, Your Honor.
Very well.
On this issue.
That's it?
As to slide 20, I will review the entire email chain and then make a ruling on it. Is Sergeant Corbett here?
Yes, he is.
They were making a huge stink about 5 documents in a 329-page PowerPoint, you guys. The documents that the judge reserved ruling on, he's going to rule in favor of the state. Scariella, no please. No please from either side. Here's Corbett.
Sergeant, please raise your right hand. Do you swear or affirm the testimony you will give today will be the truth? You do. You may take your seat.
Thank you, sir.
Dugan, I will allow you to inquire. The only thing that I would ask is that you hit the points that essentially were at issue in the last hearing. If there's other examination you have for the sergeant, you certainly may get into that as well.
Okay.
You may inquire when you're ready.
Thank you.
Showing this one again because I agree. Very good morning so far for the prosecution.
All right. Sergeant Corbett, can you tell us your name, spell it for the record?
Certainly, it's Christopher Corbett, and that's Corbitt.
Same
Okay.
Conrad.
I know you've provided testimony a lot of times in this court, but just for the record, can you tell us where you work and what you do there?
Certainly, I'm a sergeant with the City of Tallahassee Police Department, and I supervise the technical operations.
Okay, and we're not going to be asking you for any opinions today, I don't believe, but just for the record, have you been qualified as an expert previously in the field of historical communication records analysis?
I have, yes,
And about how many times?
118.
Ooh.
Thank you. All right, so I want to go through a few different things that we see in your summary quickly. Or types of things. One is going to be call detail record summaries. The next is going to be the plotting of location. The next is going to be, I want to touch on your routes, something that came up earlier today. And the next is going to be emails and texts. For summaries, in this case, did we receive phone records for Wendy Adelson, Charlie Adelson, Donna Adelson, Harvey Adelson, Fredo Garcia, Catherine McVanoa, and Louis Rivera?
Yes,
And did all of those phone records come from each party's respective carrier or phone company?
they did, yes.
Were each of them accompanied by a certification of business records?
They were, yes.
Are the phone records in this case voluminous?
Yes.
I mean, about how many pages are we talking about? Or just, I mean, hundreds, thousands, something like that, ballpark?
Ballpark is in the thousands. Just one set of records for Charlie Adelson is 4,400 pages, PDF pages. There's probably around 190,000 records that, if you put to pages, approximately maybe 8,000, and that's, I think, on the low side.
In the summary that you prepared for the state, and a copy of this has been given to the defense, which is the same copy that you were deposed on a couple of weeks ago. In your summary, were you able to narrow the parties' communication events by focusing on what law enforcement sees as significant days in the planning and execution of this murder?
Yes, I was.
Now, in the presentation, do we see call detail records summaries of communication between the parties?
You do, yes.
All right, I'm going to mark this as states one. I've shown it to defense counsel. This is just an example of one of the slides that shows the call detail record summary.
Yes, it is.
Okay. And if I could publish to the court.
Is there any objection to this exhibit?
No, Your Honor.
It is admitted as a part of this motion hearing.
Thank you. All right, so in your presentation, do we see several call detail record summaries, just as we saw on Exhibit 1, throughout the presentation for the parties' communication on significant days in the murder?
Yes.
All right, is Exhibit 1 an image of how those look?
Yes.
Is that how they look, though, when you get them from raw records from the phone company?
No.
What do you do to make them easier to read and put them in that format? How do you do that?
First and foremost is assembling all of them together into one database or one pool of information. We will assign names or subscribers to the numbers so that we can recognize which party is speaking with which party. We have to evaluate each of the events to determine if they are valid communication events or if there may be routing events or voicemail events, and those may or may not be included. We would remove duplicate events. In a summary like that, if two parties or two subjects are speaking to one another, we would have both of those events. From one party's record, it would be outbound, the others would be inbound. So we would eliminate one side of that so that we could show that it was one communication between the parties, and then it would be assembled in something that's much easier to understand and read, which is the format that you had in your exhibit.
After each one of those call summaries in the presentation, or after most of them rather, are there slides that show photos of the parties with arrows depicting the communication and then showing who communicated with who, the time that happened, and the amount of time they spent on the call?
Yes.
Okay, and what I'm going to show you, or what I'm showing you, I'll label as States 2. Is States 2 how those, an example of how those, I guess like a chart of the phone communication looks in the summary?
Yes.
All right, at this time I move States 2 into evidence.
Any objection?
No objection.
States 2 is admitted at this time.
May I publish to the court at this time?
You may.
Now this chart with the heads that has the data about the communication, are all of those charts that appear in the summary, are all of those based on the data that we see in States Exhibit 1, the call summary? So are they based on the call summaries for each of those specific charts?
They are based primarily on call summaries. Some of those would also include maybe text messages from another source, an iCloud return or a Cellbrite report. There may be calendar entries and things like that, primarily from the call detail summaries.
Okay, meaning that that's going to track a communication, whether it be a text or an email, that occurred between the parties.
That's correct.
And then you're saying that some of the charts with the heads and the arrows, when it contains the content of a text, that content would be from a Cellbrite report.
It could be, yes.
Okay. Regardless of whether it was from a Cellbrite or from the call detail records, is all of that communication in those charts from voluminous records, whether it be from a Cellbrite or from a call detail record from a phone company?
Yes.
For some of the communication events, I'm now going to move on to the location data. For some of the communication events in the call detail records that you told us about are these voluminous records from the cell phone companies, were you able to determine location data for some of those events?
Yes.
All right, and I know you've given the court explanations in the past of how you do that. Judge, do we need to talk through that today?
Just briefly, so it's
Okay.
part of the record for the motion hearing.
Thank you. Would you give us a brief summary of how you do that?
How I determine locations?
From a call detail record.
So the call detail records themselves will generally contain, for most events, the location information in the form of the cell site or cell tower that the handset is communicating with for that particular event. From that, either directly in the records or from another key or cell site database, we would be able to determine the location of that cell site, where it physically is, plot that on a map, and then start to make some determinations about location. Generally, historical cell site analysis is about inclusion and exclusion, given locations, places, times, and ask if a handset could be consistent with being at that location based on the cell site that it's communicating with, or inconsistent with that location. In addition to the cell site, we're also generally provided a side or a sector of a cell site. Most of our cell sites are broken down into multiple sides, and so that helps us kind of further narrow down where a handset may or may not be.
How does your specialized training allow you to determine the location of a handset or the distance from a cell site of a handset that a layperson might not be able to?
There's obviously a significant amount that goes into that. First and foremost, locating the cell site, determining the accurate sector or side, determining the width of that sector or side, how many degrees or how far across on a clock, so to speak, that sector might cover. Evaluating adjacent cell sites or nearby cell sites to determine what the appropriate effective coverage area of that cell site may be, taking into consideration topography, buildings, bodies of water, other things that may affect the radio signal, and then again ultimately determining if I believe that a handset could have been at a particular location at a particular time.
When you determine, or when you are able to determine location of handsets, do you plot the cell sites on a map showing the cell sites, the time that the phone was communicating with that cell site, and the sector that they were communicating with?
Yes, sometimes we don't need to be as granular as the sector, and so sometimes we only plot the cell site itself. That may be good enough for the point, or there are times, yes, that we will indicate the sector as well.
Okay, and do we see those maps throughout your summary?
You do, yes.
All right. Do you use other things besides just call detail records to help you determine the location of a handset or who may be operating a handset at the time of a certain communication?
Yes.
Okay. In this case, did you use, let's start with, are there some examples of text in this case between the parties that helped you form an opinion on a party's location?
Yes.
Okay. Are some of those examples, if Charlie McVanois and Catherine, I'm sorry, Charlie Adelson and Catherine McVanois are making plans to meet up, and do you help
or do you look to that text message to help you determine their location when you then look at the call records and maybe see evidence of other than that?
Yes, absolutely.
Okay. Or if you see a text message that says outside your house, can that help you determine a party's location when you're looking at the call detail records to see if their location is also consistent with being outside the person's house?
Yes.
In the summary, we also have, in addition to texts that have location data, we also have traffic tickets, car rental agreements, GPS pings of a rental car, Premier Jim still shot from footage, bank records of Rivera showing a picture of him at an ATM. I guess for some of those, I guess like a bank record, could that be part of a voluminous record as well?
Yes.
Some of those arguably not part of a voluminous record, like a traffic ticket or a rental car agreement. Would you agree with that?
Sure.
Okay. Why were those included though in your presentation? All those things that I just named, in addition to the text with location.
Again, the cell site analysis is about locations and times. So, for instance, the rental car agreement for the first rental car provides a location and a time. It's an address of the rental agency and a time that the car was rented. So this allows me to take that location and time and compare to the call detail records. I can look at the locations of the involved parties to determine who was present, who drove to the rental car location, who did not. The citation afterwards, the location of the citation tells me that Mr. Garcia was in a different location than Ms. Magbanowa, because we don't have Mr. Garcia's cell site locations in that time frame. So the location of the traffic ticket helps me understand that after the rental, he went somewhere different than she did. Helps me understand that at the time of the rental, where other parties were. Mr. Rivera was still at his home. Mr. Adelson was nowhere near. So we can determine again who was present, because that rental agreement gives me that location and time to compare records to. It's also the type of event. So it's a, picking up of a rental car. And so as we look at the call detail records and who may be communicating with who in that time frame, understanding generally how car rentals are conducted, knowing that Mr. Rivera or Mr. Garcia ends up with the vehicle, Ms. Magbanowa takes him out there, it's presumable that they're both in the car together heading to that event. So I don't expect really to see communications between them, nor I might not expect to see communications between Ms. Magbanowa and Mr. Adelson, because she would be in the company of Mr. Garcia. And then I know the date and time that the rental actually happened, and I would from that deduce when they separated. And then I start to see communications from Ms. Magbanowa to Mr. Adelson, because now, again, based on how a rental car generally happens, she has dropped him off, he has the vehicle, and now she will be by herself in the car and free to communicate. So all of that together goes into the analysis, if that helps.
Okay. Does the documents that you just spoke about, along with the other car rental agreement and traffic ticket, GPS ping, the Premier Jim footage, the ATM picture, do those documents help you determine cell phone location and help you form your opinion on where the cell phones are and who is using them and put the communication around them to contact?
Yes, they're all locations and times that I can compare the records to. It's a validation of the records themselves. When I see someone in a picture or a video, I expect that their handset locations would be consistent with that. And if they're not, then there was an issue. In this case, they are consistent, so that's a validation of the records themselves. Yeah.
Okay. I was briefly going to touch on the routes, but now I'm remembering that objection was withdrawn. Is the court requiring any questioning on the software he uses to route? Okay, thank you.
You may lay any record, though, you think is necessary.
Okay. At this point, I don't think any is necessary, but if it comes up later, we can. Emails and texts are the next things I wanted to touch on. In your presentation, are there several emails involving statements by Donna Adelson?
Yes.
Were all of the emails provided by Google, which is the company that Wendy Adelson and Donna Adelson use to service their email?
Yes.
Does that contain a business record certification?
It does, yes.
Now, why were the emails included in this presentation?
They were included to illustrate the content, and as far as potential motive or events that were occurring at particular times during the
Okay.
investigation.
Do the ones that were chosen involve Donna Adelson's interest in the custody battle and motive in this case?
Yes,
Are the amount of emails in this case from Google voluminous?
they are, yes.
About how many emails would you say that there are?
Wendy Adelson's account has over, I believe, 87,000. Donna Adelson's account is over, I believe, 57,000 individual emails.
Okay. And I'm just looking for a ballpark here. In your draft of your presentation, the same one you were deposed on, about how many emails did we send to defenseless emails that these are of interest to us and we may use in your presentation?
No more than 25.
Okay. Since then, have we been able to kind of whittle those down to a smaller number?
Yes, we have.
Maybe 5 or 5 to 10?
Definitely less than 10, I think 5 or 6.
Okay. But despite how many we use in our presentation, are all of those from voluminous records?
They are, yes.
As far as, we also have several text messages in your presentation that don't have anything to do with location. Earlier I asked you about texts that had to do with location, like let's go to your house tonight or outside your house, things like that. Are there several texts in your presentation that are from Charlie Adelson's iCloud or the cell rights from the phones seized in this case that don't have anything to do with location?
Yes.
All right, not going to go through them all, but do some that are going to be included in your summary, do some involve Donna Adelson's interest in Wendy Adelson's custody battle and venting to Charlie Adelson about that?
Yes.
Are there some that push back on a possible extortion defense?
Yes.
Are the
Interesting.
total amount of text that we have in this case from Charlie Adelson's iCloud or from all of the parties' cell rights, are those voluminous?
They are, yes.
About how, ballpark, how many?
I believe from Ms. Adelson's phone, there's over 10,000 WhatsApp chats, 20-some thousand instant messages. Charlie Adelson's iCloud account is, I believe, well over 280,000 messages, another probably 10 or 20,000 text messages. They're kind of categorized separately, so we're in the hundreds of thousands of messages.
Okay, and thank you for clarifying that. So when I say text message, I mean any message communication as far as text, instant message, or WhatsApp. So thanks for clarifying that. And so that we've gone from, and how many would you say we've included in your presentation to show the jury at this point?
I haven't counted them. There may be less than 20 chats with, maybe, I would probably say less than 50 actual messages. But again, I have not tallied those up.
All right, but from tens of thousands to less than 50?
Yes.
Okay, and those are all speaking to specific issues in this case?
Correct.
Okay. Those are all my questions I have for him, Judge. If you wanted to, I can address any specific slide or document that you feel I didn't ask enough about that you need more of a record on. Okay, thank you.
Mr. Rauschbaum, do you have an examination for the witness?
Very briefly.
Oh, Lord. Buckle up, folks.
So, good morning.
Good morning.
So you testified that with regards to these detailed summaries, there's thousands and thousands of pages, right?
That's correct.
Okay. But on the days that you're using, so in other words, I think Ms. Dugan showed you Exhibit 2, where you're doing the arrows. On those days, if you look at the call summary, it's less than 5 pages, right? Mostly 2 pages on most of those days.
For those days,
What?
the summary that you have may be a page or 2 pages. It took a significantly greater number of pages to get down to those 1 or 2, because again, if there's 5 or 6 subjects in that one summary, well, that's 5 or 6 subjects worth of records. And their records for a 3-day, 5-day period, maybe 20 pages each. So there's 100 pages to work down to get to just the unique communications that populate that 1 or 2 that's in the summary.
So let's get a little granular, okay? So you have one of those days is July 18, 2014.
Yes, sir.
Okay, and you do a summary of that day. If you took all your call records of that day, would it surprise you? All of them. If you took the call records for Charlie Adelson, everyone you got, would it surprise you that it's under 15 pages?
For one day to be under 15 pages, it would not surprise me.
Right. Well, I'm telling you, it's under 12 pages. Okay. That's surprising.
No.
Okay, so that's not that voluminous, right?
But that's 12 pages to get down to 1. Right?
I get it, but I'm saying if you're putting in a document, in other words, if I use the emails as an example, or the text messages, Ms. Dugan brings up that there's 20,000 text messages, or actually 12,776 text messages. You can take my word for that. You're only using, though, let's say 8 text messages. I don't know what you're using, but let's say it's 8. How long are those 8 text messages that you're using? They're less than a page, right, each?
They could be, yes.
Okay. The emails that you're using, you've got however number of emails you're using there. Wendy Adelson's email account had hundreds of thousands of emails, I presume. Right?
Yes.
Okay, but each email that you're actually putting into evidence, do you know what the longest email is of the ones that you're putting into evidence in?
Why don't you testify,
It would
Raj?
depend on how you format to print. Probably not more than 4 to 6 pages.
Yeah, it's 6 pages, right? So the actual piece of evidence that's going to go back to the jury, which is the actual email, not the 100,000 irrelevant emails that no one cares about, but the actual document that's going to go back to the jury is 6 pages long, right?
I would agree with that, yes.
Right. So we're talking about, and Ms. Dugan uses the word summaries, but these aren't summaries, right? These are just taking pieces of evidence that are already going to be in evidence and sticking it into a PowerPoint presentation, which is a way of persuading, right? A demonstrative, not a summary.
I would object to argumentative.
Sustained.
Okay, I'll move on. With
Lower
the
your voice.
location data that you're talking about, just centering on Donna Adelson, and I don't know if you have your records up there, so I'll just show you a page. And we can mark this as Defense Exhibit 1 for purposes of this hearing. This is page 271 of my version of your insurance change. You'll know it.
Yes, sir.
Judge, may I approach?
Right.
So your expertise in doing this page, am I right that what you're basically doing is you're taking Donna Adelson's call record, you're seeing when there's an event, you're looking at what location on the call record the event hits, you're then going to a map that AT&T provides you, because it's AT&T in this case. You're then looking what the longitude and latitude is on that map, and then you're just plugging it on that piece of paper, right?
That is part of what I do, yes.
On that piece of paper, is that what you did?
Yeah, I just say that, Sergeant.
No, I don't. Thank you, sir. Again, to start that, I have to go through, and this is combined. This is Donna Adelson and Harvey Adelson's records. So it's 2 sets of records. So I go through the records to find the relevant time frame, and there's 3 data sets for each set of records. There's voice calls, there's data sessions, and there's text messages. So I isolate out each of those 3 data sets for the 2 sets of records. And then I have to evaluate those records for what I consider to be valid location information. And so a number of records are eliminated based on my understanding and knowledge of AT&T records. A lot of those locations are eliminated so that I have valid locations to plot. So from that, each of the locations in the records have to be verified against a records key or some other database for me to make sure that the information provided in the records is accurate. And then that is plotted onto a map. And then from that, some estimation or determination about where the handset was during those events can be made.
Okay, let's try to simplify that. I know you like to make it a little bit more complicated than it is, but when you say you eliminate events, you eliminate them, for instance, when it says 0 seconds, correct?
0 seconds could be a factor.
Right? Why else do you eliminate? What duplicates, right?
In location information, the duration may play into the validity of data sessions. In particular, with these records at that particular time, not all the locations contained in the data sessions are accurate at the time. So I have to go in and evaluate each one of those to make sure that they are the correct usable locations for that. And I guess I'm not the one to determine how much expertise that takes, but I believe that it certainly requires it.
Well, on that piece of paper, which is all Donna Adelson's, everyone that relates to Donna Adelson looks like that, okay? So on that piece of paper, would it surprise you that all you needed to do for that piece
I
of
would
paper?
object to relevance to what would surprise them.
Okay.
Please
I'll rephrase it. On that piece of paper, you can see those times directly on either Harvey Adelson or Donna Adelson's chart. You see a call or a text message.
Yes.
You go and you look at what time it is, right? It says 8:15 next to the call.
Correct.
And then to the right of it, it gives you a longitude and latitude
It does.
for each of these. And then you take an AT&T map and you plug in that longitude and latitude, which is what you did, right?
Well, I don't take an AT&T map. I take the mapping software that we use, the Esri mapping.
Fair enough. You plug in that longitude and latitude, and it spits out a point to put a dot on a map, right?
It does.
And so even though it can be difficult, I'm not saying that there aren't examples that are difficult. In the ones that you're doing for Donna Adelson, it's on these pages. It's as simple as that. It's as simple as looking at the data, plotting it in, and doing dots.
Again, I don't know that I'm the one to quantify what is simple or difficult, but I will tell you that if you took her records and you plotted every event in that time frame, you would be plotting some incorrect locations. So it at least requires the recognition of valid locations at the very minimum.
So tell me, on that piece of paper, what events were invalid that you got rid of? Because I don't think there were any invalid on that piece of paper. I don't think there were any other cell site data that showed up. I think those are the only ones that showed up.
In that sequence, that travel sequence in those
Tell me
period
what you eliminated.
time, there are a number of data sessions, and I would have to be looking at the records themselves, that are continuous data sessions. And so they show locations, particularly from Mr. Adelson's cell phone, as I recall, of data sessions that originated at his office. And those data sessions continue to show the original location, even though the times increase. And so
You're talking about Charles Adelson.
I'm talking about Harvey Adelson.
It showed him at his office on that day,
It did, yes.
on July 18th?
As I recall,
Are you sure about that?
I don't want to say office. There are, if I can look at the records, there are data sessions that originated earlier in the day that continue to show the original location.
Okay, let me ask you a more simple question. On the actual exhibit that you're using, which starts at 8:15, I think, it plots, I think, 4 locations. On those 4 locations, were there anything that you had to eliminate in between those 4 data points?
I don't recall specifically. I can look at the records and tell you, but I do not recall if there were other things.
Well,
in
do you
that
have the
time.
records in front of you?
I have my laptop. I can pull them up. It will take a minute, but
Sure.
go ahead.
Judge, while he's getting his computer out, the court, my memory serves me, it seems like this line of questioning is Mr. Ashbaum's trying to inquire into his level of expertise and why does it require an expert to do this type of work? Did the court already, I believe the court already ruled at our last hearing that he would be able to
As an expert.
testify as an expert, form an opinion as to locations of cell phones, all of the things we would be offering him for that purpose.
No ruling was made. Ultimately, is this going to an opinion that he is not permitted to give in some way, Mr. Rushbaum?
No, I mean, I'm trying to show that there's no expertise in these particular documents. There may be in showing where Secreto Garcia's telling peaceful.
That's not
But
required.
There isn't expertise with regards to Donna Adelson's. I'm using this to show that the documents that he has chosen here, or that the state has chosen for him, that it's a demonstrative. It's not a summary exhibit as iterated under the Florida statutes. Again, we're not arguing that the demonstrative can't be used, and we're not arguing that the underlying documents can't come in. We're arguing that his presentation is not a proper summary, but is rather a closing argument that shouldn't go back to the jury.
Rashbaum is wasting time
To
now.
that point, I'll permit it, but let's not have a full cross-examination of the witness that goes beyond the issues as to the admission of the evidence.
Fair enough, Your Honor.
Either way, the jury is going to see the evidence. He's really just arguing that he doesn't want the jury to be able to bring this evidence back in jury deliberations where they can really sit and chew on how convicting it is for Donna.
Sergeant Corbett, if it's difficult to pull up, we can move on to.
Not difficult. It will be a little time consuming again.
Let's move on. I think we've made the point.
Thank you, Raj.
Sergeant Corbett, these emails and these text messages that you pulled, how were they chosen? Did you choose them?
I did not choose them, no.
Who chose them for you?
They were ultimately chosen by the state attorney's office.
May I have one moment, Your Honor?
Go ahead.
I have no further questions.
Any redirect examination for the sergeant?
No, sir.
You may step down, sir.
Sure.
Thank you, KJ and Lorraine, for your contribution to the channel. I appreciate that very much. Thank you for the stream.
In addition to the argument that was made at the previous hearing, does either party have any additional argument to offer before the court rules?
Very briefly. Or did you want the?
Whoever's ready. You are the proponent, Ms. Dugan, so you get the first crack.
All right, so we heard about several different types of items that are in the summary. The first is the summary of CDRs, an example of states one. We heard that those are pulled from voluminous business records for certain periods of time. Then we saw the charts that are basically a visual depiction of that communication that's in a phone, but in a more digestible format for the jury. It's based on data from those call detail records, from the voluminous business records, and also from voluminous records in the Cellbrite. The only thing in the chart that is from Cellbrites would just be some charts have contents of text messages in there. All the rest are going to be calls back and forth with the time and the person making the call and the person receiving the call. But all of that information is based on the data, and we can't just give the jury all of these cell phone records and say, even if a certain day is 16 pages across 3 sets of records, and say, good luck. That's why the summary rule allows us to pull this information, put it together in a digestible format for the jury. The second type are the maps with the cell site locations. These are summaries of the parties' locations at certain times that are also pulled from the voluminous cell phone records. The same records that the call detail record summaries and the charts with the heads are pulled from. Other items like the Premier surveillance footage, the tickets, the texts that talk about a person's location, the bank records, the car rental agreements. All of those things are in the summary because they help Sergeant Corbett form an opinion on who had the handset at the time and where that handset was located. And they help verify the call detail records themselves. Finally, we heard about emails and text messages. The emails are business records from Google. These are voluminous records. They're being testified to by a sergeant who specializes in communication records. He's identified and verified these as being from these accounts. There are thousands of emails. We found several emails, lots of emails that go to motive or go to the interest in the custody battle here. We're going to be using about a handful in the presentation. The same with the texts. These are maybe 50 texts narrowed down from hundreds and thousands that show certain relevant issues from this case, whether it be pushback on extortion or other things. And these are all pulled, though, the emails and the texts that aren't location data is what I'm talking about. They're all pulled from voluminous records, and they're all a summary of evidence showing a relevant issue from those voluminous records. Thanks.
Thank you. Mr. Rashbaum.
Judge, you've seen their summary. Their summary is a closing argument. It's not a summary. It's a demonstrative. Our ask here is not a big ask. The underlying exhibits are going to go to the jury. They're not voluminous. The fact that there is a universe of text messages and they've chosen 10, 15, or 20 of them does not mean that they can make a summary of it. That's not how the rule works. They can put in the text messages, none of which, not one text message is voluminous in this case. Not one email is voluminous in this case. And by the way, the call records aren't voluminous because what they're going to put into evidence are they're going to put in the overall call records, and then they can put in, if they want, a subset of the call records. For instance, July 18th. They can put in those call records. They're literally less than 12 pages. Now, we're not suggesting that Sergeant Corbett cannot have a demonstrative that illustrates the issue, but to allow a 320-page document or whatever it's going to turn out to be, which is purely argumentative. I mean, they're taking text messages and homes and cell locations, and they're all making an argument of what it means, is precisely what the court in Pete Incorporated v. Vanguard 378 F3rd 1154 cautioned against. When it said, because summaries are elevated under Rule 1006 and also Florida Statute 90.956 to the position of evidence, care must be taken to omit argumentative matter in their preparation, lest the jury believe that such matter is itself evidence of the assertion it makes. That's what they're doing here, Your Honor. They're putting a closing argument. They're trying to put his demonstrative as a summary exhibit of a closing argument to go back to the jury. That shouldn't be allowed. And so, Judge, we're not asking that a demonstrative not be used. We're not asking that the underlying documents don't come in, but we're asking that the exhibit, the demonstrative exhibit, that does not go back to the jury.
Can I briefly respond, Judge?
So briefly, it will tickle my ears and we'll move on. Go ahead.
There is no argument in any of these slides. This is all data and information from the records. There's plenty of evidence in this case that is not in this presentation that would be in a closing argument demonstrative. This is not a closing argument demonstrative.
Judge, may I briefly respond?
Oh my gosh.
Let me set my watch. It's 11:02 and 32 seconds. By 11:03, you will be done.
Argument is when you plot lines on a map and then you take a text message and you put it next to a house and you put it all together. That's argument. That's using data to make an argument. That is the definition of argument.
He's arguing against that one text message that Donna sent.
All right. As to the rulings on this matter, the court has previously ruled that Sergeant Corbett can be qualified to testify to the interpretation of historic communication data. The summary will be available to the state as a demonstrative in front of the jury. Also, in researching this matter, I came across a recent case of the 3rd DCA dealing with summaries, which I believe has A relevant ruling to this matter. This is EJD Construction Contractors and Investment Corporation versus Preston, found at 306 Southern 3rd, 1053. And ultimately, the third DCA held when a summary is accurate and not misleading, it can be properly admitted during trial. The summary may also include opinions by the individual preparing the summary.
There you
as
go.
long as the opinion is based on the underlying evidence and data that is admissible. To that point, the court will permit a summary to be admitted to the jury.
Boom.
However, the summary may include a page cross-referencing all voluminous records or state exhibits that Sergeant Corbett used in forming his opinion, his method of analysis, and the conclusions that he reached, or any inferences which may be properly drawn from the evidence. The summary is not to include any cumulative repetition of admitted state exhibits, and this is specifically going to matters such as emails, text messages, videos, things of that nature. Any inadmissible information or any opinion the witness is not qualified to give. This is going to cut down the pages that actually go back to the jury, but a summary that is based on the voluminous records and exhibits and the opinion that was reached by the sergeant that is proper and meets the definition of a summary pursuant to 90.956 will be permitted. Any additional objection that needs to be raised at the time it is offered, the defense may raise at that point. The parties need any clarification on the ruling.
No, sir.
And just so it's clear, as far as the call record summaries, and I believe the arrow charts, those will be permitted as far as being in the summary itself. The location maps, that will be permitted as well. But again, all of the other matters that are not voluminous themselves, such as any emails, text messages, or videos, it can be cross-referenced as to what the sergeant used, but it will not be a part of what is admitted. The demonstrative itself, though, can be used as the state would like to use it. Ultimately, for that, if there are any inadmissible items that still need to be ruled upon, I believe slide 20 is the only one outstanding. I will give you a ruling on that matter before it is to be used even as the demonstrative. There are no questions. We are finished at this time. I will see everyone on Tuesday morning at 8:30, and we will begin with the jury selection process. The process will be, as we did in the last trial, going through the same 5 questions dealing with pretrial publicity and any hardship. The parties will be permitted to examine the prospective jurors based on the court's question. Anything that we need to address before we finish?
Judge, there is just one scheduling issue.
Go ahead.
And look, maybe trial will go quicker. I'm hoping it does, but based on what I'm seeing, October 3rd is Rosh Hashanah, the Jewish holiday. And I just wanted to see.
I believe the court's closed on that day.
And I'll sit down now.
I'm not going to make you work on a holiday, Mr. Rauschenbaum. Yes, ma'am. For Monday, let me go through that then, based on the chart that I have with Lynn. If it's not related to this, then we're just going to finish up. We are in recess at this time. Have a good day, everyone.
All righty then. A few final moments. Oh, wow. Well, they cut that right off, didn't they? So, well, thank you guys for sticking with me. This was a long one. We started at 9. Looks like they're back. Let's see if we can get some extra footage. Leon County Detention. let's not forget where she's headed back to. Bye, Donna.
Oh, thank you so much.
See you on Tuesday when jury selection starts. It must be really surreal for her, huh, guys? Let me just go through some of these comments really quickly before I let you guys go. This is going back to the first hour when they were talking about the plea. Isabel says, I can imagine they also considered Dan's family's wishes on whether to offer a plea. That family has been through so much. You're right. The Markells have been through hell with the entire thing. Veronica says, so many dominoes are about to collapse. The family, the Adelsons, yes, prior attorneys, judges. There's a lot of speculation going around, a lot of theories going around. And I kind of feel like that's just par for the course with this thing taking so long to resolve. Veronica also saying the state is killing it. I agree. The prosecution was having a very good morning. Lou, I said good morning to you. Lou is in lurk mode. For everybody in lurk mode, don't be afraid to say hi. Do not be afraid to say hi. Say hey. Alex Morris, Carol says, has an unremarkable presence, in my opinion. A remarkable presence, I would say. In Spanish, we would say he is a piece of furniture. And Veronica, you're gonna have to explain what is the quote in Spanish. Agreed. Conrad, I hope the evidence she's speaking of right now will help them get Wendy. We heard about text messages between Donna and Wendy. Building their case, guys. Building their case. Yeah, there were some moments. Carol mentions Rashi's interminable time wasting. Can I have a moment? Get used to it when the trial starts. It does seem like he's a bit unprepared. But he has a lot going on. He has a lot of puzzle pieces to try to fit together, and they're just really pieces that are sort of coming crashing down. So get out of here, Rashford. Scariella says, every time Charlie tells Donna, don't worry, everything will be okay, he's really trying to convince himself. Yeah, keep trying. That didn't work out so well for you, did it, Charlie? Veronica's mentioning she doesn't understand how the partners at Rashbaum's firm allows him to destroy the firm's reputation with this unwinnable case, with these unwinnable cases. I mean, sometimes the bottom line is, I don't know, maybe more important. Somebody has to take the case, right? Every defendant is entitled to a defense. This defendant has money to spend, so maybe they're just saying, if their money's green, we'll take it and put something together. Sergeant Corbett did do an exemplary job in the trials and today in the hearing. You heard Judge Everett say that he is qualified to testify about historic cell site location, data analysis, all that. We knew that to be the case. I'm not surprised that that's the case. Rashbaum was really trying to discredit him as an expert witness, really trying to diminish the specialized knowledge that he has by Rashbaum saying, oh, well, this isn't that hard, is it? It's not that hard to just eliminate, duplicates from a list of raw data, is it? Corbett kept his composure, and I think he is going to continue to be an exemplary witness for the state. Veronica says again, Rashbell must have thrown a lot of temper tantrums as a child. Hashtag high pitched whines. Oh God, don't remind me. Listen, I have a toddler, and that whiny voice is just something that gets under my skin. Oof, I can't imagine Rashbell as a temper tantrum throwing toddler. Lord, don't let it be. I love Judge Everett as well. His measured approach. He's fair. He's concise. He's down to the point. He asks the questions that need to be asked in the moment. He cuts right down to the chase. Love it. Love that in a judicial person with judicial authority. Carol says, Rashi's like trying to walk with a stone in your shoe, relentless irritation. That's like impossible, right? Princess and the Pea? That's what that reminds me of. This is at the end when Rashbaum brings up that there is Rosh Hashanah on October 3rd, I believe. Since when does Donna care about Rosh Hashanah? Remember the Hitler uniforms, Donna? Donna? Remember how you suggested that your grandchildren be dressed in Nazi uniforms just to irritate your former son-in-law? Yeah. Judge Everett said that there is no court on Rosh Hashanah to his belief, so that should not be a scheduling problem at all. I just want to thank again KJ and the Ray for for the $9.99 super chat. I don't know if this is a super chat or just a I don't know. It doesn't say super chat. I'm still new to this, you guys. I'm still trying to find my way around live streaming. But you know what? I appreciate you guys being here with me for sticking it out. You could have been in any one of those other streams. We saw hundreds of people in Mentor Lawyer stream. We saw thousands of people in the Law and Crime stream. It did get back up, but you guys chose to be here. We are a community. This is like a little corner over here, and it's awesome. I appreciate you guys being here with me. Here with me, you will get a shout out here. I will read your comment. I will put it up on the screen so you can ensure that you will be seen over here in this corner. Janet, no problem. It's my pleasure. I will see you guys back here next week. I haven't decided yet if I will be streaming the jury selection. I may not, just because I have a lot going on. I'll just have flown back into town earlier that morning. So I may start back up when openings start, when opening statements are being made. So if anything, I will see you here next Friday. I have some videos, or actually a video that will be dropping very soon. I think I uploaded it correctly. I just got to review it. But you'll hear it here first. There will be a new video dropping on my channel, hopefully later on today, looking at the Adelson's rental properties. A tour? Yes, a tour, another tour. So keep a lookout for that. Please like the stream before you leave. Make sure you're subscribed so you can see when that new video drops. Thank you for being here. Have a wonderful day. Blessed and highly favored. All right, you guys. Bye.